Citizens like you that are tuning into this video, advocacy groups for the Second Amendment and small businesses have fought this war of attrition against the unconstitutional Illinois assault weapons ban. It appears that we are winning this battle, although should it resuscitate and rear its ugly unconstitutional head again, it'll be nothing but a hollow shell of what it once was. Let's dive right to it. What appears to have been a blatant effort by the state of Illinois to go judge shopping to transfer several federal lawsuits challenging the new state law banning so-called assault weapons and their magazines has backfired. Our lawsuit and others have actually all been transferred to a very fair-minded judge, said the Second Amendment Foundation. We anticipate the cases would eventually be consolidated, but instead of winding up with a judge who the state hoped would be unfavorable to the Second Amendment issues, we believe we now have an unbiased judge. All of the cases have been assigned to the U.S. District Court for the Southern District of Illinois, filed with the Illinois State Rifle Association and Firearms Policy Coalition. It is known as the Harrell versus Raoul case. This effort will likely come back to haunt Illinois Governor J.B. Pritzker and Attorney General Kwame Raoul. The governor made a spectacle out of signing an extremist gun ban law, and they immediately challenged it in federal court. The Attorney General is in an uncomfortable position of having to defend the law, and he's also a defendant in the case. Their judge shopping efforts have backfired. Last summer's Supreme Court ruling in the Buren case is making it tough for the gun prohibitionists to justify laws that have been penalizing honest citizens for decades, and new gun control schemes designed to ratchet down on Second Amendment rights even further. Illinois has to find a way to justify Pritzker's gun ban. And the state cannot possibly do that because it is not consistent with historical tradition dating back to when the Constitution was ratified. Pritzker and others like him believe the Second Amendment is a privilege, not a right. In reality, they think the Second Amendment is a loophole, and they are determined to seal it shut because the citizen disarmament is really what it's all about. We're confident the court will shut them down instead, was concluded. Essentially what happened, folks, is when this law was pushed through, the Illinois assault weapons ban, they violated the making of the law by not adhering to the Equal Protection Clause, basically saying that the Second Amendment was available to some, but not all. That is not how our founding fathers had intended it to go. The judge in this appellate court case indicates that the lawsuit is a high probability of success due to these violations. Folks, this is an awesome headway made in this unconstitutional gun grab on behalf of the state of Illinois. I must admit, I myself was pessimistic on whether or not we were going to see the light at the end of this tunnel. It appears that I was wrong. Thank God, and I had stated that. I hope I am wrong. I would encourage you, continue. This fight is not over. Continue supporting this channel as I get the word out to you about what is going on not only in Illinois, but across the nation when it comes to violations of our constitutional rights. Subscribe to the channel, hit the bell notification, comment your concerns, questions, and of course, share the video. Support other entities that are fighting on our behalf for Second Amendment rights here in the state of Illinois. Folks, I do appreciate you tuning in. As always, remain safe.